Get your feet in the car. You're a grown adult. You're acting like a kid.
Dad! Dad! No!
Welcome back to Advocacy Alchemy with Professor Ross. Today we have a good one, guys. Today we're going to my old stomping grounds, Newport, Rhode Island. I lived there for a couple years, so I know this town up close. Yacht line harbors, summer swells, and some of the most expensive mansions in the world sitting next to folks working long shifts to keep the town running. That contrast, privilege, rubbing up against everyone else, matters how we read this clip today. On August 14th, just a couple days ago, Special Assistant Attorney General Devin Flanagan was detained outside a popular Newport restaurant after staff asked an unwanted party to leave. Power, protocol, and perception all show up in this one. So let's unpack it. And with that, let's jump in.
I want you to turn your body cam off. Protocol is that you turn it off. If a citizen requests it to turn it off, she's a lawyer. She's a lawyer.
So they want you guys to leave?
Yes, we're gonna leave.
Let's just leave. Let's just make it easy, okay?
We're gonna make it easy.
No, that's not.
I am. Okay. I'm her
That's
husband.
not the point. Can you look at me?
Yeah, we'll talk over here, okay?
Your protocol is.
Can we all talk? Can we all talk?
We'll talk over here. They want you to leave.
Your protocol is.
Can we talk?
Who is she to you?
What's that?
No,
Who is she
nothing.
to you?
Nothing.
She is our college friend.
Okay. She's a friend.
Yes.
No, I'm not.
You guys just want to know? Do you want them trespassed?
Anything we can do.
Yeah.
Trespass, yeah. I just need
Trespass, get him out.
Yeah, please. It's the only way.
Okay.
No, I'm not. No, I'm not.
Do we want to chat?
I know that your
All right.
protocol is.
So you're trespassed, so we got to leave now. Unless you want to be in there.
We're not trespassing. You haven't notified us that we're trespassing.
So
Number one.
what did
Number
I
two.
just say to you? You're
You're
trespassed. Let's go.
Number one.
I don't
Number
want to
two.
arrest you guys.
You're not going to arrest us. Number two
So let's
is
leave.
that.
We got to go. We got to go.
Protocol
Let's
is.
go. Let's
Can we
go.
calm down for 1
protocol
second?
is if we
Yeah.
ask you to
I
turn
don't
the
want.
body
I don't
cam
want to
off.
deal with this. Let's
Okay.
go.
No.
I understand you don't want to deal with it,
Okay,
but the
let's go.
protocol
Wait,
is,
wait,
and your
can
protocol
you
is if I
relax?
ask you to turn off the body cam, you have to turn it off, and that's your protocol.
She's a lawyer, so she knows.
Well, that's bullshit lawyer stuff. So that's not true. So we got to go.
No, it is. That's law.
I'm an
What's she
AG.
saying?
I'm an AG.
Good for you. I don't give a shit. Let's go. We're going. Let's go.
Excuse.
We're leaving.
Please
We're leaving.
please don't put your hands on us.
Can you get your children out of here? Like, I don't know why.
I'm sorry. What?
Let's go.
Let's go.
No.
Let's go. Come on. There are two full-grown women and mothers of children. All right. Hey.
You're just being detained. You're just being detained.
I'm an AG. I'm an AG. I'm an AG. What do you
What's wrong with you?
What
What's
do
wrong
you
with you?
probable cause to detain me for?
You're being detained because you're not leaving.
Because I'm what? You have
Can you relax? Sir, she's not doing anything wrong. She's
AG.
not leaving.
I'm an AG.
Let's go.
Buddy,
You're not. She's not being arrested. Let's go.
I'm not being arrested. You're putting me in cuffs. I'm not being
Okay,
arrested.
do you have any weapons on you?
No. I'm an AG.
Her badge is in the car. You want me to go get a badge?
Let me tell you something. You're
Buddy,
arresting.
get the hell out of here. Buddy, just seriously.
You're arresting an AG. Let me tell you something.
Are you under arrest right now? No.
You're putting me in handcuffs and you're Mirandizing. You're not Mirandizing me.
Relax.
Buddy, you're gonna regret this.
Yeah.
You're gonna regret it. I'm an AG. No, take your hands off me.
We will get the license.
Get hands off
Dave,
me.
we will get the
All right,
license.
she's getting detained.
No. We will get the license.
Get out of here. Get back. Get back right now. Get back.
Detained.
No, I freaking. No.
Get back. Your cuffs.
Yep.
I'm right here. It's okay.
All right, just stuff in the car.
Here. No. I'm right here. I'm right here.
Get back.
Come on, Dave.
No.
Stop touching me.
right.
Babe, I'm right here.
No,
right
babe,
here.
babe, please, I'm scared.
I'm right here.
Please don't do this. Please
I'm
don't
right
do
here.
No, I'm not gonna find my back.
I'm right here.
No.
Okay.
No, please don't do this to my friend.
I'm right here.
No,
I'm right
no,
here.
no, babe. Babe,
I'm right here.
babe.
I'm right here.
No, babe.
Relax. Relax. Relax.
No,
Relax.
What's wrong with you?
Relax.
We don't want to put you in handcuffs. Let's go. Let's go.
No, babe, babe.
Listen, you're overreacting.
You're adding
You're
charges.
overreacting.
No. Please take my hands out. Please take them out of handcuffs. No, please take them.
You were overreacting. You didn't have to have this happen. Get in the car.
No,
Get in
no,
the car.
no! Babe, no!
You got 2 to 10.
I'm right here.
Get in the
No!
car.
Guys.
Just put her in.
No!
Get back. Get back, bro.
Get in the car. Get in the car.
Get your feet in the car.
I'm right here. Relax. I'm right here.
Get your feet in the car.
Get your feet in the fucking car.
Dan!
Babe, I'm right here.
No, babe! Babe! No!
Get your feet in the car.
Don't
your
touch
feet
me!
in the car. You're a grown adult. You're acting like a kid.
Dan!
Babe, I'm right here. I'm right here.
No! Who the are you? This is so
You're
inappropriate! You're overreacting!
So, they wanted him trespass. They were just throwing a fit. Trevor, we've got 2 to 10.
All right, once again, we're in Rhode Island. We're looking at the Rhode Island laws. They're found in the Rhode Island General Laws books. We'll start with willful trespass. That's found in section 11-44-26. Now, what does that mean? It simply means that a person's remaining on another's land or within their curtilage, that's the surrounding area of a person's land and home, after being forbidden to do so by the owner or the owner's authorized agent. If you do that, that's a crime, especially if it's done willfully. The state must prove the following elements. First, that the defendant was on another's premises. Second, they had no legitimate purpose for being there. Third, the owner or the agent forbade the defendant from remaining on the property. Fourth, the defendant willfully remained after the prohibition. This carries a fine of up to $1,000. You also can be imprisoned for up to 1 year, or you could get both of those, a fine and that imprisonment. So this is basically Rhode Island's highest level misdemeanor. They'll put you in jail right at a year. Everything over a year is going to be a felony, okay? Disorderly conduct. This is found in section 11-45-1. Disorderly conduct simply means a person intentionally, knowingly, or recklessly display conduct that disturbs the peace. That includes fighting, throwing threats, tumultuous conduct, or creating a hazardous condition by reckless behavior. Now, the prosecutor has to prove the defendant acted intentionally, knowingly, recklessly, and the conduct either actually endangered the public safety or disturbed the peace, or that it was likely to do so. Now here, we saw the restaurant staff. He was pleading. He actually had his hands in the pleading gesture. Please take these 2 away. Now, living in Rhode Island for a couple years, in Newport, it's just 2 classes, rich, poor. And the people that are rich are insanely rich. And that's from my own experience. That's what I witnessed. It could be some other further breakdown of that, but where I lived at, it seemed almost like being at a place like Hogwarts or something. But I could see some of that in how the staff were really pleading with the police that please help us. There's nothing we can do. This person is so privileged they think that they can come in regardless of what we say. Disorderly conduct carries up to 6 months in jail, a fine of up to $500. Let's move up one more. Resisting arrest. This is found at section 12-7-10. It simply means that it's unlawful for a person to use force or any weapon in resisting a legal and even an illegal arrest by a police officer when the person has reasonable grounds to believe an arrest is being made by an actual police officer. Now, when you look at the elements that the prosecutor has to meet to convict the person of this charge, number one, a peace officer was attempting to effect an arrest, or the defendant reasonably believed an arrest was occurring. And number two, the defendant used force or a weapon to resist or obstruct the officer from performing that arrest. This carries that same penalty of $500 and potentially imprisonment for not more than 1 year. So this is like probably their highest level misdemeanor. The fine is a little bit tweaked here. So instead of being $1,000, it's $500. All right, the final law I want to talk about is the Rhode Island laws concerning body-worn cameras. So they have a program that's statewide there in Rhode Island. All right, now it looks like it came into being in 2021. It authorizes the use of body cams throughout the full state. Now, they outlined the disclosure standards and they recognize some narrow, limited circumstances where officers or other agencies that use body-worn cams may pause or limit the recording. And those examples are when there are certain victims or medical privacy moments. The rule makes it clear that activation, pausing, and the release of the body cam is a matter of officer and agency discretion, not a citizen's unilateral decision. And why is that important here? Remember, the Assistant Attorney General tried to belittle the police officer thinking that she had the law correct. And basically, from what we just see here, she wasn't. It's not citizens that choose, it's the officers that choose that moment when they should turn off their camera or pause it and then restart it. All right, next, we'll go into our evidentiary standards. Okay, we go over these evidentiary standards daily. It's because they apply to every case, especially when you're going to have the police involved. But every case that goes to court has to meet some of these levels. Let's walk through them from the lowest to the highest. First, you have mere suspicion. At this level, the government, they can't make any action. And when I say the government, I mean the government or the police. So none of the agencies can act with just a simple mere suspicion. What that means is that they have only a gut hunch, no solid proof. Now, what this will do is cause the government or the police to take a closer look. They may park outside your door. They may park off of your property and watch. They may come to the scene if called by dispatch to see what's going on. They're not stopping anybody yet. It's simple, mere suspicion. Let's move up one level to reasonable suspicion. Now, at this level, the government or the police have specific and articulable facts that justify a brief stop or an inquiry to see if there's any criminal activity afoot. Now, imagine the staff telling you those people trying to come in are unwanted. They're causing a ruckus. We want them to leave. Please remove them. Now, if you're the officer, that gives you a factual basis to approach, ask some questions, and briefly detain certain people for an investigation. This level is the investigative zone, okay? You can ask, you can hold a person briefly, you can test the story that people give you. Moving up one more level, probable cause. Now, at this level, the government and the police are going to arrest someone. This is an important level for us as citizens. It's an important level for the government also, because this is when the news is going to get involved. Like here, this is why we know about this. Someone was arrested. Probable cause is a common sense, fact-based belief that a crime probably occurred and the suspect is involved. Now, if the restaurant's owner or the manager clearly forbids the group from remaining, and the group stays after being told to leave, now you have probable cause for willful trespass. This is where an arrest becomes legal. At this point, you move from asking to charging. Moving up one more level, preponderance of the evidence. Now, this term means more likely than not that our claim is true. At this level, we're talking about bringing a civil claim, going to civil court and suing over money, or suing a person saying that, okay, I already paid you to do something, I need you to come and do it. All those kinds of cases. All it requires is 51% of the evidence in your favor to win these types of cases. Now, if the Attorney General's office conducts an internal review of employee conduct, they'll decide whether discipline is warranted And that probably will be by the preponderance of evidence. We're in civil territory. Your career consequences can turn on what's more probable than not, and not on proof beyond a reasonable doubt. Here, she got arrested. All right, so she might be in violation of the policies of her office. Moving up one more level, clear and convincing evidence. Now, this is a higher civil standard, and it means that the evidence must be highly and substantially more likely to be true than not. To win these types of cases, you need about 75% of the evidence in your favor to win. Now, when an agency seeks severe career-ending discipline or some extraordinary administrative penalty, then those decision makers, the bosses, you're going to need to make a stronger showing, okay? So to discipline her, say for a sanction, a censure, slap on the hand, all you need is 50%. Now, if they're going to fire her, they might need to have this 75% evidence or more to fire her, okay? And it makes sense, right? Because behind that, you know it's going to be a lawsuit after an employee making over $100,000 is probably going to sue you if you fire them, okay? So you're going to need more evidence when it's time for you to go to court. And that's just in your best interest. Anything less will be half-stepping. Moving up to our highest level, beyond a reasonable doubt. Now, this is the gold standard. This is a level that must be met for every criminal conviction. What this level means is there's no other logical conclusion besides the defendant being guilty of the charges that have been brought. To convict someone for willful trespass, the prosecution must show every element so convincingly that no reasonable juror could have a real doubt about what's going on here. Now, if the defense can point to ambiguity about whether the owner properly forbade these two women or the group of people together, or whether the defendant actually remained, then the prosecution falls short. Remember, this is the highest standard because it does protect our liberties as citizens, okay? It makes the government have to really work if we're about to take someone's liberty away. Let's move into the jury perspective and let's ask some questions about this case. All right, now let's sit in that jury box. There's 12 people in here. You're not a commentator. You're not an advocate. You're simply a fact finder. And you bring context with you. You don't leave your common sense at the door. So with that, let's take a look at this case. Remember, we're in Newport, Rhode Island, a vacation town, the place of second homes. Newport swells every summer with tourists and money. As a high school student, I watched wealthy vacationers and service workers collide in ways that changed how I view complaints made by people and how I view warnings that are given. All that's going to matter right here. Here's the facts. This happened just a few days ago, August 14th, outside a busy Newport restaurant. The woman on camera is an assistant attorney general. Now, she's a young woman. She's only about 34 years old, but she's in a high-paying government job. How many government jobs do you know that make more than $100,000? Okay, those are our contextual facts. Not proof of guilt, but just some that lend credibility to what's going on here. With that, let's get to some of these questions. Okay, first, did the restaurant staff clearly and lawfully forbid the group from entering and remaining at the restaurant? Now, we don't know from what we saw. All we do know is that when the officer approached the staff, he said, "They're not allowed to stay. Can you please tell them they have to leave?" So the way he says that, it seems that they've already been told maybe once they can't stay. Now, Ms. Flanagan says that they haven't given her an official warning. Now, I think she might be looking for something by paper, but that's not required, okay? Number two, now after that warning happened, did the defendant willfully remain? And this is sort of a yes or no. Did they remain? They're outside. We see the sort of host station right outside the door of this restaurant. If they're remaining there, they're probably considered on the property still. Even though they're outside, there's other patrons there and they could do things that would affect the business, like tell patrons you shouldn't eat here or all those sorts of things, which you can lawfully do, but you can't do it right on the patron's property. You have to go on to public property and make those statements. Now, let's drop into deliberation mode. That's when we discuss this back and forth. Ask yourself these harder questions. Now, I've told you about the wealth divide here. Would that influence how you read the staff's complaint? Does the presence of privilege make you more skeptical of the patron's resistance or less? Now, does the defendant's status and reported salary change how you evaluate her credibility? Should it? And you really have to be honest with yourself, okay? You have to pause and you have to really think. Are you reacting to the badge or the behavior? And the badge applies both to the cops and the attorney general, okay? The authority. Are we reacting to someone says they're in a place of authority or the behavior they exhibited? Did the staff receive fair treatment by these patrons before police arrived? Now, we don't know that part of the story. That's what you would learn in court from testimony from the actual patrons themselves, the staff, and defendants. Let's swap roles. First, imagine you're a server that's asked by your manager to remove a disruptive table of patrons during a full dinner service, meaning they're bringing out courses of meals. Now imagine you're a privileged patron told to leave on a summer night. Which perspective feels more credible? Why? And if you can you tell me one concrete reason why you side more with one side than the other? So in the end, you all tell me, these two women, guilty or not guilty, and why? If nothing else, they've been seen by millions of people across the United States. The behavior is on display. Everyone's going to have different opinions of what they see. One thing's for sure, with my having lived there, knowing that restaurant, having ate there before, this is a place of privilege. This looks a lot like Karen behavior to me, but that's just me. You all tell me in the comments. All right, let's wrap things up. This clip taught 3 plain lessons. First, authority isn't immunity. Saying you work for the government doesn't override lawful orders. Second, recordings matter. Body cams fix timing, words, and gestures. And they're often the difference between reasonable suspicion and probable cause. Third, de-escalation can be so powerful. Your intuition, it can help you stay out of trouble, out of the back of a police car, out of handcuffs. Use it. When you watch Law and Order on video, don't let emotion steal the facts. Anchor your instincts to what you can see and hear. Ask which legal standard fits these facts. And remember to check your bias about status and privilege at the door. Now, if this video changes how you see this encounter, tell me why. Leave your verdict in the comments below. Like, subscribe, share this video. Remember, this is Advocacy Alchemy, and I am Professor Ross. I'll see you tomorrow. Everyone be safe out there. Have a great day.
If you've got ideas or videos you want me to lecture on, send them to the queue. And come back tomorrow at 8:45 a.m. for another lecture.